Today, the topic is about relationship between fundamental rights and directive principles. Introduction. Fundamental rights and directive principles are integral components of the same organic constitutional system, and no conflict between them could have been intended by founding fathers. Part 3 and 4, that is, the fundamental rights and directive principles respectively, together constitute the conscience of the Indian Constitution. History and origin. The fundamental rights and directive principles had their origins in Indian independence movement, which strove them to achieve the values of and social welfare as the goals of an independent state. The development of constitutional rights in India was inspired by historical documents such as England's Bills of Rights and the United States Bills of Rights and France's Declaration of the Rights of Man. In 1931, the Indian National Congress at the Karachi session adopted a resolution committing itself to the defense of civil rights and economic freedom, with the stated objectives of putting an end to exploitation, providing social security, and implementing land reforms. Other new rights proposed by the resolution were the prohibition of state titles, universal adult franchise, abolition of capital punishment, and freedom of movement. Drafted by Jawaharlal Nehru, the resolution, which later formed the basis for some of the directive principles, placed the primary responsibility of carrying out social reforms on the state and marked the increasing influence of socialism and Gandhian philosophy on the independence movement. The Constitutional Assembly of India, composed of indirectly elected representatives from the British provinces and princely states, commenced its proceedings in December 1946 and completed drafting the Constitution of India by November 1949. The drafting of the fundamental rights was influenced by the adoption of the Universal Declaration of Human Rights by the UN General Assembly and the activities of the United Nations Human Rights Commission, as well as decision of the US Supreme Court in interpreting the Bill of Rights in the American Constitution. The directive principles, which were also drafted by the Subcommittee on Fundamental Rights, expounded the socialist precepts of the Indian independence movement and were inspired by the similar principle contained in the Irish Constitution. Meaning of fundamental rights and directive principles. Fundamental rights. The fundamental rights embodied in the Part 3 of the Constitution guarantee civil rights to all Indians and prevent the state from encroaching on individual liberty while simultaneously placing upon it an obligation to protect the citizens' rights from encroachment by society. The purpose of the fundamental rights is to preserve individual liberty and democratic principles based on equality of all members of society. They act as limitations on the powers of the legislature and executive under Article 13, and in case of any violation of these rights, the Supreme Court of India and the High Court of the States have the power to declare such legislature or executive actions as unconstitutional and void. The 6 rights recognized by the Indian Constitution are right to equality, right to freedom of religion, rights against exploitation, cultural and educational rights, right to constitutional remedies. The fundamental rights are not absolute and are subject to reasonable restrictions as necessary for the protection of public interest. Directive principles of state policy. The directive principles of the state policy embodied in Part 4 of the Constitution are direction given to the state to guide the establishment of an economic and social democracy as proposed by the preamble. They set forth the humanitarian and socialist instructions that were the aim of social revolution envisaged in India by the Constituent Assembly. The state is expected to keep these principles in mind while framing laws and policies, even though they are non-justifiable in nature. The directive principles may be classified under the following categories, such as ideals that the state ought to strive towards achieving, directions for the exercise of legislative and executive powers, and rights of the citizens which the state must aim towards securing. Despite being non-justifiable, the directive principles act as a check on the state, theorized as a yardstick in the hands of the electorate and the opposition to measure the performance of the government at the time of an election. Significance of the fundamental rights and the directive principles of state policy. Significance of the fundamental rights. Number 1. The fundamental rights were included in the Constitution because they were considered essential for personality of every individual and to preserve human dignity. Number 2. The fundamental rights help not only in protection but also the prevention of gross violations of human rights. Number 3. The emphasis on the fundamental unity of India by guaranteeing to all citizens the access and use of the same facilities irrespective of background. Number 4. Fundamental rights also protect individuals from any arbitrary state actions. Significance of the directive principles of state policy. Number 1. The directive principles are intended to an egalitarian order once the limitations or resources is overcome and state is competent enough to fulfill them. Number 2. Directive principles exercise an important check on the government. As rightly remarked by Dr. Ambedkar, the directive principles can be the best election manifesto. Number 3. The directive principles guide both the government and the people in the realm of politics and society. They have significant educative value. Number 4. The directive principles also emphasize the goal of welfare state and social justice that are guaranteed in Indian polity and keep check on elitist or populist measures. Application of the doctrine of harmonious construction. Though the judiciary continued to hold that the directive principles were subordinate to the fundamental rights, an attempt was made to achieve the ideals mentioned in directive principles. The Supreme Court's view regarding the interplay of directive principles and fundamental rights underwent a change. The court came to realize that there should not be any conflicts between two sets of provisions of the Constitution which have a common origin and a common objective, as would nullify either of them. The way out was found to lie in the doctrine of harmonious, arising out of the canon of interpretation that parts of the same instrument must be read together in order to reconcile them with one another. Applying this doctrine, the Supreme Court came to adopt the view that in determining the ambit of fundamental rights themselves, the court might look at relevant directive principles. The doctrine of harmonious construction as a new technique of interpretation in this field was introduced in Hanif Qureshi Muhammad versus State of Bihar, AIR 1958, Supreme Court 731, where the court invalidated a ban on the slaughter of all cattle on the ground that it constituted an unreasonable restriction on the right to carry on a butcher's business as guaranteed by Article 19, Clause 1, Clause G, notwithstanding the directive under Article 41. However, it was stated that the Constitution has to be interpreted harmoniously and the directive principles must be implemented, but it must not be done in such a way that its law takes away or abridges the fundamental rights. Otherwise, the protection provisions of Part 3 will be meaningless. Relationship between directive principles and fundamental rights. There are three possible views on the relationship between directive principles and fundamental rights. The first view is that the fundamental rights are superior to the directive principle, so that the directive principle must give away to the former in case of repugnancy or reconcilable conflict between the two. The second view is that fundamental rights and directive principles are equal in importance, and hence, in case of conflict between the two, an attempt must be made to harmonize them with each other. The third view is that the directives are non-justifiable and are more in the nature of positive affirmation of the state. However, in recent times, some of the directives have been made a part of chapter on fundamental rights to be in time with the requirements of changing polity. The important question is where there is a conflict between the fundamental rights and the directive principle, which should prevail. The conflict arises when the state needs to implement a directive principle and it infringes or abridges the fundamental rights of the citizens. The conflict between fundamental rights and directive principle came to the Supreme Court for the first time in State of Madras versus Champakam Dorairajan, 1951 to Supreme Court Review 525. The Supreme Court held that Article 37 expressly says that the directive principles are not enforceable by court. The Supreme Court mandated that the chapter on fundamental rights in the Constitution is sacrosanct and the directive principles have to conform to and run subsidiary to the chapter on fundamental rights. This means that fundamental rights were given superiority over the directive principles. This continued for a decade and a half. Then, in Golaknath versus the State of Punjab, AIR 1967, Supreme Court 1643, for the first time, a bench of 11 judges of the Supreme Court was formed. The court in this case laid down that fundamental rights cannot be abridged, diluted to implement the directive principles. This decision forced the government to amend the Constitution. By the 24th Amendment Act 1971, the Parliament amended Article 13 and Article 368. This amendment made it clear that Parliament has the power to amend any part of the Constitution, including fundamental rights, and the word law as used in Article 13 does not include a Constitutional Amendment Act. In the Kesavananda Bharati versus State of Kerala, 1973, Supreme Court 1461. The Supreme Court ruled that Parliament could amend any and every part of the Constitution, including fundamental rights, but it could not destroy the basic structure of the Constitution. However, in Minerva Mills versus Union of India, 1983 Supreme Court Case 625, the Supreme Court held that the Constitution exists on the balance of Part 3 and 4. Giving absolute primacy to one over other will disturb the harmony of the Constitution. This took the Article 31 Clause C to its prior condition that a law would be protected by Article 31 Clause C only if it has been made to implement the directive in Article 39 Clause B and Clause C and not any part of articles included in Part 4. When a social conflict arises out of the conflicts of the fundamental rights and directive principles, the state should emerge as a torchbearer because ultimately it is the superiority of the social interest over the individual interest. However, it is the duty of the court to resolve a conflict with an eye on the Constitution and another on the social harmony. After the Minerva Mills case, the Supreme Court is of the view that there is no conflict between the fundamental rights and the directive principles of state policy, and they were complementary of each other. There was no need to sacrifice one for the sake of the other. If there is a conflict, it should be avoided as far as possible. Conclusion. It will be seen that the development of law regarding the conflict and irreconcilability between fundamental rights and the directive principles has passed through 4 distinct stages. At the beginning, a strict literal interpretation was advocated and the fundamental rights would prevail over the directive principles. Later, in course of time, a perceptible and a welcome change came over the judicial attitude, and the court subordinated the directive principles to the fundamental rights, took the view that the mechanism of harmonious construction should be used to interpret the two parts. Later, the judicial began expanding the directive principles and interpreted the two parts as being co-equal and without any conflict. However, in the 4th stage, the judicial stated that there should be balance and harmony between Part 3 and 4 and that none should be given a primacy over the other. Since both the fundamental rights and the directive principles were of common origin, it is clear that they both had the same objectives, namely to ensure the goal of a welfare society envisaged by the preamble. If the fundamental rights seek to achieve the goal by guaranteeing certain minimal rights to the individual as against state action, the directive principle enjoined the state to ensure the welfare of the people collectively. Thank you.